Right. It doesn't tell the minister what to do, but if you have the right arguments, there's always the opening that you could get that turned around because it's not law. There's no law that says the minister is not allowed to do it. There is pending law that says the minister is allowed to waive any deadline under the Act other than that one deadline for SR&ED. That's really what the new law says, but it's not passed. The minister may decide to follow the recommendations and not grant it to you. I'm just saying that legally, well, yeah, the tax court can actually make a ruling on that. They can ask the minister. You can basically have a reason why it was late, and if the minister thinks it's a valid reason, they may do it. I'll tell you, the reasons that I see are things like sickness, flood. If you've got a very good, I had cancer for, I don't know, they may, I'm not saying they're guaranteed, you may have a situation that the minister decides for whatever reason, infinite number of reasons, is warranted. And right now, the minister, all I'm saying is the minister could do it. When this law is passed, even if the minister completely sympathizes with you, it doesn't matter. The minister's not allowed to do that anymore. That's all I'm saying. I'm not in any way guaranteeing the minister would do it. I'm just saying the opportunity's there. All right. Now, so status of the current legislation, I'm saying if we look at the March 2012 budget, got royal assent around December. If it applies on the current one, we can expect the 2013 changes about, reporting requirements and stuff we're talking about now to come in roughly end of the year. So the reporting requirements, but also the informal appeal levels to go maybe between now and December to double up to the 25,000, more than double, 12,000 to 25,000 of taxes payable. Meaning, if you've got one that's waiting, and it's more than 12,000, you may want to wait a month or two and see what happens until the threshold goes up higher. All right. All right, section 3, first two sections down. New CRA pronouncements. So we talked about what the Department of Finance said. Now we'll talk about CRA publications and interpretations. So we're talking about a new T661 form coming out in October. It's going to reflect the changes that we just talked about for 2013. There's the new policy releases, consolidated policy documents. So where they took all the ITs, ICs, application policy papers, everything, and just made one, I guess, list of master policy documents, but a series of documents. Most of which I think financial are fairly consistent with the old documents, although they're a little vague in certain areas, and that's leading to new issues popping up. But the one that creates, of all the papers that were released, the one that creates the most concern is the one called Eligibility for Work for SR&ED, which is basically the replacement of Information Circular 86, which talked about what qualifies from a technology perspective, as opposed to the ITs, which talk about all the financial issues. We'll talk about new, what we call RFI, or Request for Information procedures, that the CRA has been using to ask clients for information. Not really a site visit, but a precursor between a desk audit and a site visit. We'll look at a new CRA software example that was released towards the end of last year. And then we'll talk about the 10 examples, the draft examples. We'll discuss them in detail, the ones that were just released last week. Okay? And then the implications of the YMPE going up each year. So as we talked, the new form will be coming out next month. It's going to take into account all the changes announced in the 2013 budget, which hopefully they'll be passed by then, including prepare fees and all the other ones, and the 2012 budget, so the prorations that we saw there. You can still file the current form until the end of the year, but starting January 1, you have to file on the new form. Okay. The consolidated policy documents replace, as we said, all the ITs, ICs, and application policy papers. According to the CRA's release, it doesn't represent any change in policy. It's just a clarification of policy and looking to remove some former ambiguities. what I think is probably the most significant part of that whole thing is a new analysis that the CRA put out about how their three-part definition of SR&ED correlates to the tax court's 5 questions or 5 criteria that they're using to evaluate SR&ED to show how they parallel or match up. Before I jump into that, I'll take a preamble back and talk about the international definition of R&D. So a group called the OECD, Organization of Economic Cooperation and Development, back in 1963, developed something called the Frascati Manual, and they update it about every 5 to 8 years. They do an update on it. And the definition that we have in the Income Tax Act of SR&ED is verbatim, word for word, the definition of the Frascati Manual. The fields of science that we use and the numbers and everything are verbatim what they use in the Frascati Manual. So Canada didn't invent any of this. We've copied word for word the international legislation on what R&D is. And it's not just us. If we look at the IRS code, they copied it too. Inland Revenue, everyone uses the same international definition. So I'm saying, well, if we're all following the exact same definition, then probably a lot of the directives the OECD provides on what R&D or SR&ED is probably relevant to us because we have the identical definition. By corollary, the interpretation should be identical. Okay. So we'll talk about defining the SR&ED project in the CRA's paper, what the tax court says versus the CRA guidance. Some of the things that we'll talk about is the role of the Tax Court of Canada, what they feel their role is versus the expert witness, their SRED process, the definition of something called the scientific method and how that applies. And that's becoming more and more prevalent. And I think that's a very good thing. And then compare those requirements for the project eligibility, tax courts and CRA. What we'll do is we'll use a very simple view here to say that the CRA's 3 main steps actually correlate to the Tax Court of Canada's 5 criteria. If we take the CRA steps and break them into sub-steps, they kind of match up. But it's hard to make a one-to-one correlation, as I'm going to illustrate on the next slide. So they talk about the Northwest Hydraulics case and 5 questions that the judge asks in it. Now, I won't spend a lot of time on this, but they ask about risk, whether there's technological uncertainty, 5-stage process of the scientific method here. So the objective, uncertainty, hypothesis, and testing of it. And again, that seems to be the international definition of scientific method. No matter where you go in the world, I have clients from Asia, Africa, South America, North America. If I say, do you know what the scientific method is? Every single one of them will say, yeah. Objective, hypothesis, experimentation, results, conclusions. Every language, everywhere around the world, universal definition. So I'm saying it's really easy when you recognize that to explain to people what we want. It's what they've always thought of as an R&D project. So the fact that the CRA is starting to acknowledge that what we're doing for project description is actually the scientific method is fantastic because it's intuitive to everyone. It makes our job so much easier. So did the procedures follow the scientific method? That's what the court's saying. Irrespective of what CRA says, the court says you have to follow that scientific method, or else it's not SR&ED. Did it result in technological advancement? Now, I'll talk about advancement, and I believe the advancement is the conclusion at the end of the day is the advancement. Whether a hypothesis proved correct or incorrect, that's my conclusion, which they say represents a technological advancement. I don't like asking for it up front. I'm saying the way we do it in Canada is all backwards. The rest of the world says scientific method is objective, hypothesis, experimentation, results, conclusions. In Canada, we say, no, it's conclusions, objective, hypothesis, experimentation. And when you flip it upside down, it's very hard for people to intuitively understand what you're looking for. I like to do it the scientific method way, which is intuitive for everyone. Okay? And lastly, do we keep a detailed record of the hypothesis? So this gets to our documentation issue. Do we keep enough documentation? And that, what's relevant documentation is probably one of the perennial issues that we're always dealing with. So in the case of RIS Christie, the judge clarified. He said, here's what the expert witness is, whether it's the RTA or the scientist for the claimant. They're saying the RTAs don't ultimately decide what is SR&ED or not. That's the role of the Tax Court of Canada. The RTAs can advise the judge or make sure that the judge has information to support the assertion one way or the other, but they say ultimately the ultimate decision on SR&ED is a legal decision. It's a question of law to be determined by the Tax Court of Canada. The scientist's role is clear. The expert's role is to work as a set of prescription glasses for the judge to view the technical information, to make the technical information relevant and understandable so the judge can focus on the key issues and make an informed decision. Okay? So it's never up to the RTA or the scientist whether something is SR&ED. It's up to the tax court. It's up to the scientist to make sure that the tax court has the right information to make an informed decision. Okay, so now they talk about the 5-stage process in the case of Northwest Hydraulics. We'll talk about this in relation to the CRA's criteria. So the first thing that I did is when I was doing my own analysis, is the way that the courts work when you're interpreting something is if we use a term that's not already defined in the Act, like scientific method. What you're supposed to do is take what is the generally accepted definition of the scientific method with no hidden meanings or whatever. So you can look at an Oxford definition, Webster's definition, any generally accepted definition of what is the scientific method. So I said, well, here's the scientific method from Oxford Dictionary, and here's how the recommended tax court or project description method matches up to those. And so is there a matchup or is there not? And I'm saying the scientific method is really appears to be the guiding principle for the claim. Taking then this CRA chart, which is the first 2 columns, the CRA matches up. They say, let's take the 5 questions that the tax court asks, and then we'll interpret how their 3 criteria fall into that. So they say the first criteria of the court is, was there technological uncertainty which couldn't be removed by standard practice? CRA says, well, that's our technological uncertainty criteria. And I'm saying, well, kind of, but I think it's beyond that. I'm saying, really, I think that's really the first 3 steps. To do an uncertainty beyond standard practice, first you have to define standard practice. Then you have to show objectives that go beyond that. And then you actually have to talk about what uncertainties that creates. So that's really the first 3 steps of the process, not a single step, in my view. Did effort involve formulating a hypothesis specifically aimed at reducing the uncertainty? So they're saying that's the activities, the content stage. I'm saying I think that's more the uncertainty stage, but whatever. It fits in there somewhere. Was the adopted procedure consistent with the total discipline of the scientific method, including formulating, testing, and modifying the hypothesis? CRA says, well, that's just the content, the last stage, the activity stage. I'm taking a step back and I'm saying I don't interpret that the same way at all. When you say, are you following the scientific method, that's everything. That scientific method is project, objective, standard practice definition, hypothesis, experimentation results, conclusion. That's the complete scientific method of Oxford Dictionary. It's not just the activities that you do at the end. If I tell you just the activities, I haven't followed the scientific method. I'm missing 4 of the major steps. I've only hit one part of it. Did the process result in a technological advancement? So CRA says, well, this is the first stage. I'm saying, no, I think that's the very last stage. I think the advancement is the conclusion at the end of the day, but a conclusion isn't necessarily a technological advancement. A conclusion is only a technological advancement if I've hit all the other steps above it. If I've benchmarked standard practice clearly and accurately. If I have an objective that goes beyond that. If I can clearly enunciate my hypothesis. What are the variables that I'm working with? If I've done the work systematically. If I've recorded my results and then made conclusions, then I have technological advancement. If any one of those was missing, you don't have it. Yeah, whether I succeed or fail from a business perspective doesn't really matter as long as I conclude. So whether I fail doesn't mean I'm in or out. What matters is, did I stop at, very often what I see, otherwise potentially eligible projects falling short, is they go to the results. Hey, we got to this point, option number 4 is the best out of the 10, let's go ahead with it. And that's the result, but it's not the conclusion. The conclusion is, why is number 4 the best? Why is number 4 better than number 7? Can we explain what we know now about why that one was better than the end? So it's always the why. The conclusion at the end of the day is the advancement. Even if I conclude, hey, we can't do this, or this variable, or we think this doesn't work because we believe these variables have more of a weighting than we anticipated before, that would be clear of a technological advancement. They actually reiterate in here, proving a hypothesis is incorrect represents it. I don't use that term advancement other than at the end, other than to say the advancement is an important term because that's the only term in the Income Tax Act that we're following here. There's no uncertainty. The only thing the Act says is contemplate technological advancement. That's all I have to follow to meet the Act. How do I do that? How do I prove to the judge that there's technological advancement? The judge is making it simple. I don't even need all these questions. Did you follow the scientific method? Question 3 is everything. And it's universally known. Every engineer or scientist I've ever spoke to in any country, every language, knows exactly what I'm talking about. I don't have to teach them anything. Well, you're right. And they do say what advancement was contemplated, but ultimately, like I say, the advancement is easier to look at the conclusion, because I don't know if it's going to fail, right? Ultimately, my advancement is always the same. I want to understand the interrelation of these variables better than I do now. If I outline the variables and show there's no model to do that, that's really the hypothesis I'm saying in any field of science. Yes? Right, so they're saying that as long as you understand, and I would say that the real thing is not just that it didn't work, but always ask the why. The real difference on saying, hey, it didn't work and we know it doesn't work, that's still not good enough. Why didn't it work? And you don't even have to be right. You just have to be making an educated guess for someone skilled in the right direction. You could still be going on a blind angle and a year later figure out if you were actually going in the wrong direction. It's the attempt to understand that. It's really the conclusion. So the question is, do each of the criteria have equal weighting, or is one more important than the other? I don't want to comment on that. I would say they're all critically important, because if any one of them is missing, you're going to lose. And I can show you in the tax court cases where we went earlier, I can show you ones that lose on there's no advancement. I can show you other ones that they didn't benchmark standard practice. Other ones where it's uncertainty is the issue. Yeah? What I call the trinity, or the 3 shapes, or 3-legged stool, or tripod, or whatever you want to call it. Now it's a 5-legged stool. It's a pentapod, or whatever. Pentagram. All right, so this is basically the model that I'm going to use to say I believe the scientific method from a practical perspective. If we want to follow the scientific method, what do we have to write on a piece of paper? That's what the engineers want to know. So the government gives me money and I don't waste any time. So do whatever you got to do to say you benchmark the state of existing knowledge. The more searches you do, the more due diligence, the better. How much is enough? I don't know. There's no right answer. My rule of thumb is, you should probably do more initial due diligence on a $10 million project than on a $10,000 project. But how much more? I don't know. It really depends on the facts. You may have a $10 million project that's so advanced that only 2 people in the whole world even understand it, and you know the other guy, so you already did it. There's nothing to do. Whereas a $10,000 project may have lots of competing technologies that you have to look at. So maybe the $10,000 project needs more. I don't know. I would say a rule of thumb is the bigger a project, the more due diligence that most companies normally would do, but the science is always going to drive the claim. Every situation is unique. You can make generalities, but there's always going to be an exception to that. Okay? I recommend that you provide measurable objectives. We'll talk about tax courts say systematic investigation must involve extremely accurate measurements and analysis of those measurements. They say without such measurement and analysis, systematic investigation cannot exist. So if you don't start quantifying things from an early stage, you're going to start running into all those kind of problems when you hit the tax court level. Ultimately, the term hypothesis, a lot of people don't get that. What does a hypothesis mean? What a hypothesis means is that I have a predictive model. Almost every predictive model is mathematical, according to Wikipedia. Whether I'm in medicine or aerospace or computer science, whatever I'm attempting to do can generally be modeled mathematically via variables. So if I'm testing your chance for cancer, I can turn it all into mathematics. I'll say it's a combination of your age, your blood type, your weight, and maybe 50 or 60 factors that I pack together. And I say your age has less of an effect than this or that, or in combination, certain things may have more of an effect. They may have an additive. Do you smoke? Do you do these things? Lifestyle issues. So there could be tons and tons of variables of which we have an idea how they work, but we want to refine the model to make it work better. And that's all SR&ED in every field. It basically breaks down to predictive models that tell us what's standard practice, and then things that can't be predicted with those models, which are beyond standard practice. Okay? Then the last part is once we get the work itself, how do we ensure that the researchers tell us things that are only SR&ED, that they don't include the non-SR&ED portions? And how do we make it clear to them as to what we want so they don't waste a lot of time? What I find the best way to do this is to get as many people involved on the process who have the ability to design their own experiments. Not a clerk who's told exactly what to do, but someone who's said, hey, go solve this problem, figure out a solution. That person should be empowered to see what the team agrees as the variables, input on that, what they think the top 5 things that are under their control, the things that they could change in order to meet the objectives. Okay? What things can I change or vary as an engineer or scientist in order to achieve the objectives and understand why that did or didn't work? And if we can outline and rank the top 5, it provides clear direction, I find, for everyone in there to say, hey, you know what, I was just dealing with those issues, which the 4 prototypes I did here, I think helps the team understand one or more of these issues better. Perfect, document it, and you've got a good basis that that's quite likely SR&ED. The other thing is, how do I convince the reviewer on the other end who's never met me, who's doing a desk review, not a site review, that not only all the work is in, but the costs are reasonable. And really what I believe is you want to tell them how many alternatives you looked at and how you did it. Did you just analyze stuff on a computer? Because computers are fast. They're at the speed of light. I can analyze 1,000 alternatives in a day. But if I have to go and do process trials where I have to run it through a line, maybe each of those takes 10 hours. Or if I have to build a complete prototype, maybe that's hundreds or thousands of man hours. So how many alternatives and which of those 3 main methods did we use usually would give someone skilled in the art an idea of whether something's 300 hours or 3,000 hours or 30,000 hours. I won't tell them for sure, but it'll give them a feeling of whether it's grossly plausible or not. If you say we looked at many, many experiments, well, that doesn't really tell me anything. I was in a review of a large company. It was over $1 million, and it was written on less than a sheet of paper. And I remember looking at these guys. They went through very easily. We did 28 different prototypes in 7 different classes. Or actually, it was more than that. It was like 50 prototypes in 7 different classes. Here's what's different in each class, and here's the differences within there. And the reviewer's asking, hey, did you build forms? Did you build models? Yeah, here we do. Here's some pictures of it. And he said, hey, I understand. I believe each of these was at least 500 to 600 man hours, because I used to do work like this in industry. And I understand all your problems, what you were varying, and why that was necessary. Assess this file. Okay? But what he did is he said, 43 alternatives times 500 man hours per alternative, yeah, there's your $1 million. If I said I did many, many alternatives, so that's not how a scientist speaks. Scientists use extremely accurate measurements according to the tax court. Anyone? What's 500 man hours times many, many? I'll tell you, it's going to be a site visit. They're going to come and find out what many is. And that's my experience. You're better off telling them. A lot of times clients say, I don't know. I say, well, give me a guess. At least 50. I did approximately. That's still better than nothing, than many, or you think I'll fool them with terms like several or various, or those are layman's terms, which tax courts say scientists don't talk like laymen. Scientists use extremely accurate measures. Laymen or non-scientists use general terms like big terms like many or various, right? Very bad idea to use those kinds of vagaries I'm finding in a project description. So really, it's seeing what's the right information to put in the first place, and if you focus the description on the right issues, I find the process is still pretty manageable and streamlined. All right, so let's walk through what the tax courts have said about the different definitions here. So on defining standard practice, the CRA said all work recurs to standard devices and processes that are routinely used in designing dams. Now, the case of Northwest Hydraulics was that these two individuals who were both professional engineers and PhDs, they were university professors, that they were building these dams for the U.S. military and doing various amounts of experiments. The CRA's position is because they were so skilled, nothing could be a problem for them. They knew everything there was ever to possibly know about building dams and optimizing it, so everything was just fine-tuning. They were always going to get the answer to every situation. And the tax court disagreed entirely. They said, no, these guys are incredibly knowledgeable, but they clearly benchmarked what they knew and what the voids of their knowledge weren't, and what they were learning by the experimentation. So again, they provided good examples about something that the CRA thought was routine engineering, but it ultimately became the variables that they identified in each of the projects that made it eligible. And the fact that a choice of one of these variables had unpredictable upstream or downstream effects on the other ones. If I change variable Y, that may affect variable X or Z in an unpredictable fashion. One of the key things that the U.S. government does, the IRS, which is brilliant, in my opinion, and very fair, is they have something called a rebuttal presumption. So if anyone's seen a science reviewer's opinion that says, I think this was routine engineering, period. I think it was routine engineering, period. What do you mean it was routine engineering? The client documented how there was no off-the-shelf solution, all the things they did, the variables, whatever. How could you say it's routine engineering? All the facts lead against that. And here, sadly in Canada, they can say, I've seen stuff like it before, I think it's routine, end of story. And once an RTA puts their opinion down, it's getting harder and harder to change it. Nobody wants to politically change that opinion ever. Whether it's justified or not with science is completely irrelevant. It's more, I don't want to hurt this person's feelings. Let's put the science aside and just worry about the feelings of the RTA. Again, this is a scientific credit. I'm not here to entertain people's feelings or personal vagaries about what they think something should be. The law is very clear. In the United States, if the IRS scientist or reviewer decides that it's routine or standard practice, they have to show you where the solution was. Here's the printed solution. If you would have followed this, you would have had it. Right here on the internet, here's the website. If they can't, the IRS says it's in. They must show you where the solution was readily available to you in order to say it's routine or standard practice. They can't just say they think it is. They have to prove that it is. Like a scientist. Just like what the claimant is, they're holding themselves to the same level of documentation. They have to actually provide evidence to support their assertions. Brilliant. The other thing that they do is if you get a patent in the States, they automatically qualify you for the tax credit. So that's a neat streamline. Okay, quantification of objectives. Why do we want to quantify objectives? I'm saying CRA is not really strict about quantifying the objectives, but the tax court is adamant. If you go to tax court and you don't have quantified objectives, you're going to get killed. They have a much higher level of reporting, I would say, than the CRA does, who you could maybe sneak through without that. In SaaS manufacturing, they say, quote, systematic, and they repeat this over and over again in many, many cases. Systematic investigation connotes existence of controlled experiments and highly accurate measurements. Testing is one's theories. They say, without such measurement and analysis, systematic investigation cannot exist. So again, if you don't start right from the start quantifying objectives, comparing the results, using extremely accurate measurements about how did I vary, you can run into big problems all the way through this. When you hit the tax court, that may not even be a problem with the CRA. So I'm saying that the criteria, the CRA is making an attempt to follow the tax court, the ultimate rulings criteria, but I'm still saying I don't think they're there yet. They still got a big void to follow to close that gap. They clarified that most scientific research involves, in fact, infinitesimally small progress. You don't have to be 10% better than you were before. You could be a tenth of 1% better as your objective, as long as it involves scientific or technological uncertainty. Some definitions of the word hypothesis, and we won't spend too much time on this, but it's a tentative assumption that creates a logical plan to resolve a problem. They talk about it as a starting point for further investigation that should be based on standard practice. So first we've got to figure out what our standard practice knowledge is, do our due diligence, and then talk about known facts, what's known and what's unknown. What are the variables that we think we know, and what are the variables, the things we could change that we don't know exactly how those changes are going to interrelate. So in the case of Northwest Hydraulics, the landmark case, the judge ruled that despite that the CRA thought that these guys should know everything because they were so skilled, that standard practice engineering could not deal with the variables that the client identified, the variables for experimentation, that in turn created the uncertainties and the basis for eligibility. So to look at that very quickly, scientific hypothesis. Wikipedia, we'll take a generally accepted definition. Say, to be scientific, a hypothesis has to be measurable or testable. We need quantification so we can test it. They look at observations that can't be satisfactorily explained using standard practice or existing models. Wikipedia says normally hypotheses have the form of a mathematical model in any field. It doesn't matter. Mathematics, science, whatever. Variable X, W, Y, we're changing things to make something happen. What are the things that we're changing? Well, that's really the judgment of the researcher. What are the things that he or she could change to make this happen or not happen? What I like to say is that you can use these variables then to build a test matrix. And that's really how most formal engineering does it. They say, here's the things we're going to test, and here's our test matrix that we're going to go through. And then we have what the courts call controlled experimentation. I always thought, what do they mean that you have to have controlled experiments? I think, well, really the way you control experiments, first we have variable X, temperature. We'll try 10 different temperatures and see what happens. Okay? Variable Y, pressure. We'll try 10 different pressures and see what happens. That would be a controlled experiment. You're controlling each variable to understand its relation to the others. I don't know how else you would meet the tax court's criteria without following that framework. Okay, now to the ending stage, the activities themselves, systematic investigation. They talk about repeatable experiments. So again, this gets to the documentation. What do we have to keep at the end of the day? How do we gain knowledge on the hypothesis? So in Rainbow Pipelines, they say what may appear routine after the fact may not have been routine up front. Just to say, hey, that looked routine or obvious now that you've shown me the end solution, as a CRA may say, hey, that's just routine engineering. So it says, well, it may look routine at the end of the day, but you actually have to look at what happened to get there. What distinguishes routine work from SR&ED is not what they say, just systematic routines, but the adoption of the entire scientific method. So I'm saying scientific method is all we have to follow. Scientific method encompasses all the 5 steps, with a view to removing technological uncertainty through formulating and testing of innovative, untested hypotheses. So again, I think that if we want to simplify it, we just say project descriptions have to follow the scientific method. And there's only one criteria then, or we can break that into the 4 to 5 steps. That the advancement is really, I believe, the conclusion. They're saying, quote, rejection after testing of a hypothesis is nonetheless an advance, and it eliminates one other hypothesis. This doesn't happen at the start of the project. You conclude on the hypothesis by doing the work at the end. It's the conclusion that's the advancement. It's not the start, it's the end. Very failure reinforces the measure of technological certainty. So as we said, the failures, we're not going to spend $100,000 doing something we knew would fail. If we did it, it's probably because either we thought it would work, or maybe we thought it might fail, but we wanted to understand why. We wanted to analyze it further. Either way, it's a very positive indicator of technological uncertainty. It could also be random investigation. We don't know what we're doing. So again, you're going to have to look at the facts, but again, it puts it in the right perspective. So we talked about the rebuttal presumption already. I won't talk about it too much more. But basically what the IRA says is if the taxpayer demonstrates with credible evidence, so they did their due diligence, hey, we did what we think is reasonable search and we couldn't find it, that their activities exceed common knowledge in the particular field of science, the commissioner must demonstrate that it's common knowledge. They can't just say we think it is. Hey, I've seen stuff like that before. It must be. They have to prove it. They have to prove it just like the claimant has to prove it. Scientist against scientist, not scientist against non-scientists with personal opinions. It should be scientific all the way through. So it's really a matter of asking the right questions. If we don't ask the right questions, particularly what is standard practice at the start, we're off on the wrong tangent. We're wasting all our time. We don't really have any basis, what I call the foundation of the square. We're not thinking outside the box to begin with. There's nothing to build on. Okay, new RFI procedures. So we'll talk. So that ends my preamble on the criteria. Since around January, maybe late December, January 2013, instead of doing site visits, really what I'm seeing happen is it's kind of a difference between a desk review and a site review. They don't really want to come out and do the site review, but they're asking for information. So it's RFI procedure. I don't know what percentage of claims are experiencing the RFI procedure, but I think it's probably at least 50%, judging on my clients. And I find that there's really three categories of questions. There's standard questions that appear nationally, no matter who you deal with. It seems to be kind of like a form letter. But then there's certain questions that appear to be specific to certain district offices or TSOs. And then there's other questions or comments that appear to be unique to the individual RTA reviewers or who's ever asking for the information. So there seems to be a general framework, but a certain amount of discretion amongst the TSOs and then even amongst the RTAs themselves on how they adapt those questions to their particular personal audit or review style. The first of it is a request for sample information. So they say, please send 5 letter-sized sheets of information which you feel best demonstrates that work meets the SR&ED. So that's high-level judgment. Which of my 5 pages, if I got 500, are the best 5? And that's a great question. It shows professional competence to rank them. I'm saying, if the team has actually ranked the issues in order of perceived significance, that should be relatively easy. It's the ones that deal with the biggest issues, the ones that they agreed as a team were the real showstoppers. But it doesn't stop there. At first you think, oh, that's easy. It's just 5 pages. That should be a piece of cake. But then you read the fine print and it says, in addition. And I go, oh, wow. It's just in addition there. Wow. What does that mean? If not included in the above sample, which is only 5 pages to begin with, please send us copies of contemporaneous evidence that shows you recorded initial due diligence activities, i.e., how did you define standard practice? This is relatively new. I mean, it's always been there. But I haven't seen them actively asking you to prove your due diligence activities to the extent they are now, which is, again, the more due diligence you do before you start, the better it's going to be. Recorded the plan you devised, and then showed that you preserved the technical knowledge, i.e., you have to clarify what the conclusion is. Not just, hey, product 7 is the best or alternative 7. Why? Why is that one the best? So I think these are all actually very relevant questions and timely, but they also are kind of stepping it up over what traditionally the client was expected to provide. I'm not saying that's a bad thing. It's actually a good thing. It seems very focused on relevant stuff. But a lot of clients, if they haven't got a formal plan, are missing at least one of these 5 criteria. And now any one of them is going to leave you open to a counterattack. It's not like you can do 4 out of the 5 and get away with it like before. Any weak link here could spell doom. New focus on weekly timesheets. So they're saying for salary, wages, and contract labor, please provide an org chart. No big deal. Details of activities for each SRED project claim, including number of hours claimed for each individual, per activity, per month. And for each contractor, a copy of the contracts, statement of work. They actually say not only each activity per month, but they say, and tie it into how you distinguish the SR&ED activities from non-SR&ED. So they want details, and some people ask for it by week, others by month, but they really want to know not only how you claim the project, but how you differentiate. You didn't just put a project code in and say, well, everything in that project code's in. How you then looked at the project and said, what's the SR&ED and non-SR&ED components, and did that forward. So again, a lot of claimants, when they're getting this, are like, whoa, we've never got, holy smokes, this is a lot of work. We have to now, for 80 employees, we have to sit there at every timesheet for every week for, every month, start putting this together and explaining it. It can be a lot of work. It could be pretty onerous. I'd say the trick is to start tweaking your system so it's capturing this real time. Tweak your timesheet so that they're getting that information when the people fill it out, and then it should just really be a matter of printing stuff out. Well, could be that. They're just asking you to say, prove to us that you've differentiated the SRED from the non-SRED. They don't tell you how to do it. They're just saying, you better have that figured out. So my answer is, how do you ensure that you've figured that out and that you're providing the right information? That's the real question. What I'd say is, I'm not going to really change a client's timesheet system or get them to adopt one that I have. Every client's got their own timesheet system, and they love it, and they've spent, they've got all kinds of champions for it. Going in and telling them, scrap that and use something else, that's not a good business decision, I would find, in my business. But what I can do is say, hey, you've probably got timesheets already. Let me look at your timesheet and see if maybe we can just add 1 or 2 items or correlate it or add a little bit of direction to it to tweak your system, existing system, so you keep using it, but it's going to provide me the information that might be otherwise missing. So all we really need, I would propose at a timesheet level. I'm just proposing this. CRA doesn't publish what would be an acceptable timesheet. They just say you have to have them. There's no examples anywhere that I know printed. Is name of the person, hours worked, and then this is really what they say. How do you link that to SR&ED? Ultimately, when you look at the Act, it lists 8 types of supporting work. Engineering, design, operations, research, mathematical analysis, computer programming, data collection, testing, and psychological research. But really, when you look at them, they group into, you're either doing design, you're doing testing, you're doing programming, or you're out of that, you're the first level of supervision. And those are really the only 4 activities that are going to be SR&ED. If you're doing any other stuff, writing manual, anything that's not that, we could say operational research or whatever, but those are really just subsets of design or testing in most cases. If you're not doing one of those things, then start to ask yourself. Each employee could ask themselves, why do I think it's SR&ED? And the answer here, which is optional, but this would be the ultimate, is if the teams communicated on what they think the variables of uncertainty are, the things that they could change that they don't know what the optimal solution is in choosing that, then they could talk about how this work in any way relates to one or more of those variables. So that would be the ultimate if we could pull that off. And then whatever comments. The last thing that a lot of them are missing is the location of the work. I'm amazed at how many timesheet systems, because I'll ask them, well, how much time did the guy spend in Ontario? Was he in any other provinces, or was he outside of the country? Then we have to do all these manual, like the timesheet system doesn't catch that. And I'm like, oh, we got to look at the guy's travel logs and whatever. I'm saying maybe if someone's traveling a lot, just add that other field, location of work, so at the end of the day, we don't have to go scrambling. We know exactly how many hours here to the hour. We'll have everything available. So like I say, a lot of this in retrospect seems obvious. But I'm saying that it's not obvious at real time. Most timesheets don't record location of the work. And yet, if you don't do that, you could have huge problems at the end of the day. You could have a material misstatement on the claim. You didn't ask the right questions, or they didn't tell you, and it becomes privy to CRA that someone's outside of Canada.